Let's start with I.B.F. versus A.D.K. and another. 2024 ZAGP PHC 296 under the pen of Swanepoel J. Bundle pages 103 to 115, 22 March 2024. So, folks, I'm not going to go into the whole history of this matter. This is in the context of an extremely complex and extremely acrimonious matter involving the Hague Convention, contact and care, parenting coordination, and it's a big laundry list of issues dealt with. The matter had several court appearances. These culminated in a rule nisi, which was ordered on 31 August of 2023, which rule nisi was then confirmed in a judgment earlier this year. And this is essentially reasons for the judgment. So the background of I.B.F. versus A.D.K. and another, incidentally, the central authority also being cited in the judgment or in the proceedings as a party. The first judgment can also be found on SAFLI. I'm not going to go through it. That is 31 August 2023. Same case citation, just a different date. The previous judgment sets out the background. I'm going to give you a little bit of it. The applicant resides in SA with the children. The first respondent, who's the father, resides in St. Martin. And essentially, the first respondent sought the return of the children to St. Martin, and various applications, counter applications ensued. This was a family that moved around quite a lot. Mom is eventually settled in South Africa. Dad brought an application under the Hague Convention to have the children returned. In this instance, the children were not returned under the Hague Convention, and very lengthy litigation ensued. Now, why I've put this under procedure is not because I didn't know where the heck else to put it. It's because there are a couple of very interesting procedural questions in this matter. The reasons for judgment given by Swanepoel J in this instance related to punitive costs given, as well as why the respondent's application for a postponement was dismissed, and why the rule nisi in terms of the August order was confirmed. Now, what does this judgment look at in terms of the procedural? It looks at the conduct of legal practitioners in correspondence. The court says, the court makes very, very strong findings in terms of the tenor of the correspondence by the father's attorneys. For example, in paragraph 5, in my view, urgent application was a clear abuse of process. It was launched in the most urgent of timelines, some 8 days after the applicant had requested details of the holidays. Urgency was not specifically dealt with as required, nor do I believe the application was urgent at all. Furthermore, the request by the applicant for an itinerary was reasonable, and had the first respondent acted in a more conciliatory manner, the application may not have been necessary at all. I intend to express my displeasure for the respondent's conduct. There are quite a few other paragraphs in the judgment also castigating the tenor of the correspondence. Then, in finalizing the rule nisi, I'm going to just look at paragraph right at the bottom. My apologies, it's cut off a wee bit on my slides there, but it's a very, very long quote. Paragraph 19. The court essentially says, overall, the children seem to be settled in their current home and school, and it is my view in their best interest to have certainty as to their circumstances. For that reason, I intend to confirm the rule nisi. However, going forward, there should be an assessment of all the parties to establish what interventions may be necessary to assist the parties and the children to stabilize their relationships. Very interesting that the court gave clear indication of the assessments required.